and I don't want to forget to do that. So hopefully it's recording. Yep. Okay. Good. All right. We have Drew Pierce, Dylan Gilkey, Garrett Leet, who needs to cut his tie in half, Josh Sally, Riley Reynolds, Russ Curry, and Travis Eaton.
Yeah, Professor Head was the one that told me to wear a tie.
You know, you can never overdress.
No, that was my thought, honestly.
Yeah. Alex and Josh Hurt joined us. All right. So let's start real quick with trying to get a little feedback from you all in terms of what you see in other professors doing with their final exams and the like, and compared to what I'm doing, which is essentially still holding a final exam and doing in a narrative portion. Are there recommendations that you would have for me as far as any potential changes to the final exam? And if you want to comment verbally or use the Zoom group chat, either one of those is fine. Make sure to unmute yourself. All right, any recommendations at all? All right. So, review session, just real quick. Of course, I've sent out announcements. If you go to the exam study guides, you will find the actual final exam questions, and then you'll find the exam study guide for CPAs 12 through 17 there, and at 6 o'clock tomorrow morning, Project 18 or CPA 18, whatever you want to call it, will also be added to that. Reminder, Project 18 is due at 11:59 tonight. All right. If we were to look at my answers to projects 12 through 17, basically I just took all of the fact scenarios and gave you my approach to answering questions and the like, with a little bit here and there of some potential additional things. What was interesting to me is there were some questions in the project questions that I actually had a difficult time answering or couldn't even find the answer sometimes. It wasn't in the reading, and surprisingly, it wasn't easily found by online research. I ended up grading these projects pretty easily, especially the last several of them, because I realized that some of the questions that I had asked, especially on asset protection, were sometimes very difficult to answer. And then let's take a look at the other thing here. We have the actual exam questions here. Now, I was going to make up 21 questions, but after I got into it and started devising questions, I only came up with how many? Let's see, 11, but a couple real big questions. One of those is the whole federal estate tax question, and the other one, I believe, had to do with the insurance question, which is not quite as big. And then there's other questions of varying length here. I guess this question on education planning is pretty big. So we have the exam coming up, and I am going to choose questions from this list of 11 questions. The questions on the exam will be identical to the questions that I posed here. So in theory, you could actually write out all of your answers, and then whatever questions I ask, you could just copy and paste your answers over during the exam and submit it and have it all done. Again, if you can't take the exam next Friday, please email me and I'll arrange a different time for you. You'll probably get a different version of the exam as well. Exam is 2 hours long, and it's open note, open book, open internet, and it's worth 306 points. So that's a big part of your grade, 30% or a little bit higher. And again, one of the long questions with multiple subparts, and then some of the shorter questions will be thrown into there as well. And what you'll do is download, I'll do this via Blackboard, the actual exam, as a MS Word file. That way you can just work on it offline for 2 hours and then get back online and upload it. You can type your answers. If you do choose to handwrite them, that's fine, but you should scan your document as a PDF file to upload it to Blackboard, and a lot of phone apps nowadays have a scan to PDF software out there. And it is possible that I might actually give different versions of the exam, where I might do this by email, where I might give one block of students one version, another block of students another, and another block of students another. So instead of downloading from Blackboard, you actually might get an email. I'll let you know that before I do the exam. And during the exam, if you have any questions, you can email me or text or call me. And it is going to take me some time to grade these exams. All the grading is still done on an A to F basis. For your final grades, we don't know who has signed up for pass-fail grading, so that means that we still have to grade every exam as if it was a numerical or A to F grade. And expect that the grading on the final exam will be certainly a lot more intense in terms of the scrutiny that I give it than I did to the projects. And then we come to the actual questions. So I'll open it up at this point and say, what questions do you have on concepts that you would like to go over or the like? Again, you can do this through the chat room, or you can just open your audio and ask them verbally. Or I can start singing, which you don't want to do. For those of you who can see me, I've got a bit of a beard. So I'm either going to become Santa Claus by December or turn into a polar bear, one of the two. All right, so let's just go through the questions. I figured we might not get a lot of specific questions. Term life insurance, amount and duration. And so question number 1 on the spring 2020 exam questions. All right. You're a new personal financial advisor. You're making $50,000 a year, but 5 years from now, you anticipate making $100,000 a year and expect that to go up with inflation. You're getting married. Your spouse is, for example, a teacher, going to make $45,000 a year consistently, and if you were to die and have one child, your spouse would receive a small amount of Social Security benefits for the care of your child, probably just going to cover the added cost of child care. You don't have any substantial savings at this time, but you are saving 17.35% of your paycheck. And in addition to that, you're paying FICA taxes and income taxes. So when you do make $100,000 a year, you'll basically be spending $55,000 a year. On top of that, you're going to have $20,000 in total federal and state income taxes. How much life insurance should you obtain in your life? Well, the primary purpose of life insurance is to replace lost income. And in this case, we're going to assume that you're relatively young, so you might have a 40-year, 45-year, maybe even 50-year work history going forth. And when you get to having such a long work history, basically what you need to do is just basically rate a lump sum that's going to replace the money that's lost. That lump sum should grow at a rate equal to inflation so that the income from that grows at a rate equal to inflation. And we're going to assume that the income we want to replace is this gross amount of $100,000 a year, but the net amount is $55,000 a year plus taxes, federal and state income taxes. Now, the taxes on an investment portfolio will be less than the taxes on ordinary income because you have qualified dividends, you don't have realization of all capital gains and the like, but there will be some taxes. So one of the ways that you could do this is say, what is the amount that I have to replace every year? And perhaps that's somewhere in the neighborhood of $65,000, $70,000 a year. Basically, the amount that would be spent out of your salary to maintain the standard of living that your spouse and child would have. Your spouse, of course, would continue to be working in all likelihood. So we might say $70,000 is what's needed. And then the question is, well, how much does it take to generate $70,000 a year? Traditionally, the rule of thumb has been a 4% rate of withdrawal from a portfolio. Well, if you divide 4% into 100, you get 25 times that and the like. There is concern that that 4% rate of withdrawal might not be sustainable for some reasons. For example, population growth is lower than it was in the past when a lot of the 4% studies were done. Interest rates are lower right now than they were historically in terms of investment rates of return and the like. So a lot of people might suggest that, hey, maybe we ought to multiply whatever amount we need by 33. So if we were to take, and I'll just pull up my little calculator here. $70,000, and we multiply that times 33, that gives us 2,310,000. Okay. So that might be the amount of insurance that we want. Now, life insurance is typically, especially term insurance, is typically sold in kind of round numbers. I mean, you could come with an exact number, but it could be like 1 million, 1.5 million, 1.75 million, 2 million and the like. So a safe bet here, somebody making $100,000 a year of income and having basically enough that will provide for spousal support until age 100, as well as support for the child, could be 2,310,000, and you might round that either up or down, depending on how comfortable you feel with the number. And that's typically what somebody making about $100,000 a year of income, $2 million of insurance, or $2.5 million, somewhere in there. What type of insurance should you buy? Almost always term insurance. Whole life insurance, universal life, variable universal life, equity indexed universal life. All of those policies build up cash value within the policy. It builds up cash value tax free, but getting the money out of the policy becomes very difficult. It can actually cause some of the policies to implode. Probably the major reason is just the cost of the premiums. The premiums are going to be 10 times what the cost of term insurance is. And you don't have to replace income forever. You're basically trying to replace lost income here. So how long do you need to replace this? If this person is able to save 17.35% of their paycheck, chances are 30 years from now, 40 years from now, child's out of college, don't even need to have any insurance at that point because the size of their investment portfolio should be pretty good. Most of the time, you can now buy insurance up to 30 years. You purchase a term life insurance policy that has got level premiums for 30 years. So that would probably be a good idea, especially since they're starting to have a family here and you want to make sure you have that insurance in place through the time that their child is likely to graduate from college. Now, term life insurance has a conversion feature. Sometimes you'll see term life insurance that has you can convert it for in the first 10 years of the policy or the first 20 years of the policy. I bought a 10-year term policy a long time ago. I won't date myself, but it could only be converted in the first 5 years. And I actually ended up converting it because the cost of getting new insurance was going to be a lot higher for me. So I converted it to basically a variable universal life policy. You definitely want to preserve this conversion feature. The conversion means I can change this from one type of policy to the other. The premiums go up, way up, but now you have permanent insurance. So if the health situation changes, if term insurance, life insurance is a bet. Right? It's a bet against your life. It's a bet you don't want to lose, don't want to win. All right, but I've had clients who were 60 years old and in really bad health, and they had term life insurance for 20 years, but they could be converted. And the question was, should we convert it? Well, if their health was really, really bad, sometimes it makes sense to convert it at that point. And in a situation like this, where you have 30 years of term insurance and somebody's perhaps starting work at age 22, 24 years old, that only gets them to their early 50s. So definitely you would like to see a conversion feature or this conversion option where they can convert at any time within that 30-year time horizon. The other nice thing about term insurance is it's a very competitive marketplace. There's a lot of companies out there that issue it. You certainly want to stick with highly qualified financially secure life insurance companies, but you're not putting really your money at risk here. So if an insurance company were to go down, for example, a lot of times state regulators will have another insurance company take over their policies or something like that. Even then, I would stick with buying term life insurance from highly rated companies. All right, any questions on that? Well, obviously, when you answer a question like this, I'm asking you to put it in your own words. If you were to have this question on the exam, my feeling is when you have to put things in your own words, it kind of demonstrates that you understand the concepts better, and that's my goal of doing that. Talk about the 401k rollover question. For financial advisors, this is an important question because a lot of times you'll be dealing with clients that are retiring. They probably manage their 401k account by themselves. It might all be in a target date retirement fund, for example. And as they approach retirement, as they accumulate a larger body of assets, they feel uncomfortable about managing that themselves, and they really have no clue about what to do when they retire, how to take money out of this portfolio. So here we have the Hawk, age 62. He's done very well in his 401k. He's accumulated $3 million. But the plan, as most 401k plans, has a limited investment options, and a lot of times you can do better than what's in a 401k plan. He has a contributory IRA account, so you only put a couple $1,000s in it a long time ago. It's worth $5,000 now. Should you transfer the funds from the 401k account to the IRA account? How should you do that? And really, there's kind of two parts to this question. One is how should you do it? There's something called a direct trustee to trustee transfer. What you find in dealing with 401k plans as a practical matter is the record keeper for the plan, the third-party administrator, basically wants you to sell everything in your 401k plan, and they want to issue a check. And that check could be written, for example, directly to the new custodian. Whether you're working with Merrill Lynch, it could be payable to Merrill Lynch with your client's account number on it, or it could be paid to TD Ameritrade or Schwab or Fidelity if you're independent custodian working with them, something like that, independent advisor working with them as your custodian. You want to do a direct transfer from the trustee of the 401k plan to the custodian of the IRA account. That way there's no tax withholding. If you have the check issued to your client, there's mandatory tax withholding, which means you're not going to be able to roll over the whole thing. The other thing is, if you don't do that rollover in 60 days, if that client just hangs on to that money, then you can't do the rollover anymore. So always try to effect what's called a direct trustee to custodian transfer of the money. I don't think that part of the question was actually spelled out very clearly here in terms of how to do it. I think the focus of the question is basically, should you put it into a contributory IRA or a rollover IRA account? And there are, in fact, two different types of traditional IRA accounts here. The contributory IRA account is an account that somebody sets up and makes their own contributions to the account. A rollover IRA account is from rolling over from a qualified retirement plan. If you have contributory IRA accounts and rollovers, you don't want to combine them, because for asset protection purposes, under ERISA, 401k accounts and also 403b accounts, 457 accounts, pretty much the same thing as 401ks, are all protected unlimited from an asset protection standpoint. If you got sued for $1 billion, they can't take your retirement account. But that's an unlimited limit. That unlimited limit also applies to rollover IRAs. But if you mix contributory IRA money in there, then you no longer have that. So regardless of what you call the account, if in filing bankruptcy later, they go back to your records and they find out that you mixed a contributory IRA account with a rollover IRA account, you're going to be limited to the asset protection limit for a contributory IRA account. And I think that's somewhere around 1.4 million, somewhere in that range at this point. So always do a rollover into a rollover IRA account. That limit, by the way, adjusts every 5 years with inflation. You started at $1 million and it goes up. I think it went up last year, so it has a few years to go before it adjusts again. And you'll find that limit in the answers to the projects that I posted. Alex posted here, for the cost of college, I use a Vanguard college based on 19 years, spending 4 years in college, 8%. I projected total cost of $486,000. I thought this was a bit high. Your thoughts? Oh, cost of college. I don't think that you'll see 8% annual cost increases in the cost of college. There's certainly the cost of college has outpaced inflation in terms of what tuition costs are. A big part of that is because state funding for college has gone down dramatically. It used to be that states provided more than half of the operating budget of a university. On average now, it's about 1/4. And certainly coming out of this economic crisis we're in, there's probably going to be some further cuts. Even after the great financial crisis, 2008, 2009, though, most states restored those cuts. Kentucky did not, unfortunately. Um, I would probably use, in terms of your cost of attending college, probably the rate of inflation, or maybe just 1% higher than that. A way of looking at it, if the cost of attending college right now, like a public university like WKU, is $22,000. If inflation is going to run 3.5% in terms of the cost of college, that's likely to double in 20 years. So 20 years from now, 22,000 becomes 44,000. Multiply that times 4, and you come up with a cost of about $200,000, somewhere in that range. Yeah. All right. And you could factor that into this first question here on term life insurance. But the way I put this question here, you're saving 17.35% of your paycheck each month. Not all of that goes to retirement savings. Some of that could be debt reduction, saving for educational costs and the like. We have an educational cost question here. So any questions on the 401k rollovers, contributory versus rollover IRAs? Okay. Protecting assets with umbrella insurance. Your client has a net worth of $5 million, and although you suspect she has secret offshore accounts, being a member of the Avengers, she does not tell you about. You are very concerned that she is a reckless driver. So you're very concerned about her liability, but more important, she's got a high net worth, or anybody who's got a net worth and wants to protect those assets. If they have assets to protect that are not protected because of the nature of the asset. For example, all of my IRA accounts, 403B accounts, are protected from credit claims, but the equity value of my house is not protected. So I have a house that's $350,000. Yeah, it's set up by Tennessee by the entireties, but if my wife passed away and then I was sued for some reason, pretty much most of the value of that house could be taken, so I want to protect that. And how much auto insurance liability coverage do you recommend for her? Well, in order to get umbrella liability coverage, which is that extra $1 million or $2 million or $4 million or whatever, you basically you're required under the terms of the umbrella policy to either have $250,000 or $300,000 of underlying auto liability coverage. Most of the time is $250,000. Sometimes you'll see $300,000, and sometimes, like Geico says, whatever you can get, either $250 or $300, because different insurance companies will have different liability limits that they'll give you. Pretty much the maximum liability limit on an auto insurance policy is $500,000. But you don't need $500,000 of auto liability insurance, because the cost of auto insurance liability is actually greater than the cost of umbrella. But you still need that $250,000 to $300,000 of underlying auto liability coverage. So if you were in an accident and you got sued, your auto insurance liability pays for the first $250,000 or $300,000 of that. Umbrella insurance also covers, for example, slip and falls at home. I've had some clients who have experienced that, where a guest at their house slipped and fell, and it slipped and fell because there was something that should not have existed, whether it was water on the floor or an upturned mat or something that caused people to trip. So you definitely want umbrella liability insurance, and on top of your homeowner's insurance, you want to have $300,000 of liability coverage. The next question is, how much of an amount should you get? For the longest time, I recommended that most of my clients get $1 million of coverage. Over the last 5 years, I've switched that to $2 million, simply because it is quite possible in an auto accident case to basically injure somebody permanently and see a claim well in excess of $1 million nowadays, just the cost of providing someone. Then the question is, do you really need to insure against the remote case? You know, you're driving and you hit a surgeon who's 40 years old, who's making $800,000 a year, and now the surgeon is disabled. Well, you might have a $10 million claim there, or a $20 million claim, in terms of what it would take to replace his lost income and the like. But the likelihood of that occurring is very, very remote. So for most people, I would recommend $2 million of umbrella insurance. I think that's going to solve 99% of claims, maybe higher. However, if you have a high net worth person, somebody who's worth $5 million, it's not the amount that they need to protect. It's the fact that they become more of a target for those who might want to sue them. The higher your net worth is, the more likely it is you are going to have somebody file a claim against you. So in a case like this, Natasha, $5 million, you might recommend $3 or $4 million of insurance coverage, just because they're more of a target for that reason. And the cost of each additional million is not that much. So when you have higher net worth people, they can easily afford that additional coverage. So again, my view of this is the auto insurance and homeowners insurance, underlying insurance, 250 to 300,000, whatever the umbrella insurance requires, and then get, for most people, $2 million, but for really high net worth people, probably get $3 or $4 million of coverage. There are some people who are public figures and have higher net worths, and you can see umbrella insurance like $30 million, stuff like that. That's an unusual situation. We wouldn't expect you to address that on the exam. Okay, any questions about that? All right. Corporation versus a limited liability company. So you got two people who are starting their own company, and they're going to license their images for use on school lunchboxes. They will each own 50% of the company, and it will be a pass-through entity for tax purposes, which means it's going to be treated as an S corporation, or if it's an LLC, either an S corporation or a partnership. Should your clients form a corporation or a limited liability company? And corporations for the longest time were the only entity out there, but about 30 years ago, limited liability companies came into being. And limited liability companies are typically better for most operating companies than regular corporations, really for two reasons. If you have a corporation, you have to keep annual minutes. You have to follow some certain formalities. If you don't follow those formalities and you're sued because of some activity within the company, then they could do what's called piercing the corporate veil. And if you haven't followed all of the requirements for maintaining that corporation, having annual minutes and the like, you could easily be sued. And the corporation basically does not provide you a shield from claims that exist within the company. Limited liability companies, you don't have to keep any minutes or anything like that. So it's a lot easier. But the primary reason here really relates to, what if Captain America is out there and, you know, is saving the world, and in the process of doing that, he hurts other people, and those other people sue him. All right. Then the question is, can they take his stock in a corporation, or can they take uh, the what are called units of ownership in a limited liability company? And the answer is someone can take your shares of a corporation that you own. That's pretty easy. You just attach it, you get a judgment, and then you attach it and you take those shares. There's really no restriction on a creditor's ability to do that. But for a limited liability company uh, that has more than one owner, in most states, there's going to be significant asset protection for that. Uh, Basically, a creditor cannot attach or take those units of ownership. All they can get is a charging order against that limited liability company. It basically says if there's any distributions out of the limited liability company, if this was for example, a partnership that did, if it was taxed as a partnership and they did distributions, or taxed as an S corporation and issued dividends, all right, a limited liability companies can be taxed as an S corporation. Uh, Either way, they can attach and take those distributions if they have what's called a charging order. The problem with charging orders is uh, if somebody were to get a charging order against this type of company, and Captain America and Spider-Man might say, we're not going to take anything out of the company. We're just going to let it grow. All right. And if that was the case, then that charging order, they might have to report income every year because it's a pass-through entity for tax purposes. So the creditor who has a charging order gets hit with a 1099 that says, here's the profits of the 50% of the corporation, and you have to report them as income, but the creditor hasn't gotten any cash. So basically, a limited liability company is a better way of basically protecting you from outside creditors in this case. A creditor is not involved in the company, but relating to a creditor of one of the individual owners themselves. What really happens in these cases is that basically the charging order, the limitations of it, become kind of used as a way of settling the claim, uh, knowing that it's very difficult to get this. However, in some states where limited liability companies are really, really protective, like the state of Florida, where you can have multiple owners. I've seen somebody who owned a $6 million yacht in a limited liability company. They were sued for medical malpractice, and the creditors never got to the limited liability company. There was no income generated by that yacht. So basically, there was just no ever settlement of that. So primarily, the greater asset protection here comes from the charging order process, the limitation that you just can't take the units of membership of that limited liability company. You can only, as a creditor, get a charging order against it. Now, there are some states where you can actually foreclose on a limited liability company. If you have a sole owner limited liability company, that is quite possible, in which case most states you can foreclose on a single owned limited liability company. In Kentucky, there's actually a process for foreclosing on limited liability company. Just um, even if there's multiple owners of it. However, there are preconditions to doing that, and I'm not 100% sure on what all those preconditions are. I don't practice in Kentucky, um, but and you don't need to explain it for purposes of this exam. Certainly, when a client wants to form a business entity, their first stop ought to be an attorney to help them choose the form of business entity. Their second stop ought to be a CPA to make sure that they have the right tax structure, partnership, S corporation, C corporation for that business entity, and also that they set up their accounting and tax reporting records correctly. Um, and probably the third step would probably look at insurance for the company. So you can guide your clients to basically say, if you're starting a business, there are some professionals you need to go see, and here's the order in which you are to do them. Um, any questions on that? All right. This fifth question, protecting against elder abuse, you're a dual registrant. So your firm is both a broker-dealer firm and a registered investment advisor firm. Broker-dealer firms basically sell products. They get paid on commissions or 12B1 fees typically. Um, Investment advisory firms get paid by the client. It might be a percentage of the assets that they manage. It could be a flat fee every year or hourly fees or some combination of that. There are a lot of firms out there that are both broker-dealer firms and investment advisory firms, and there are people who have both licenses as a registered representative of a broker-dealer firm and also an investment advisor representative of an RA firm. So your client, you're a dual registrant, has begun to request $30,000 cash withdrawals, periodic withdrawals, above and beyond the monthly withdrawals that you set up for her to help her live for the rest of her life. And when you inquire about this, you find out that Edith is giving these large amounts to her new friend, Jack Sparrow of Pirates of the Caribbean fame, not a very nice fellow, who's younger, and you believe, based on your conversations with Edith, she's in love with Jack, and you believe Jack is basically using this as a means to unduly influence Edith to make large gifts to him. This is actually quite common, believe it or not. A lot of, I wouldn't say a lot, but some retired women are very susceptible to what is basically, there are actually, I would call them gangs, where they basically recruit people to follow a script of how to make someone fall in love with you and start taking their money. There's actually basically criminal enterprises that do that. So the question is, what steps should you take? And I'm not going to repeat all those steps here, because if we go back to the questions here and the class preparation assignment and all the answers for that, here we are. Project 13, protecting against elder abuse. You're a registered representative. What should you do? You're an investment advisor. What should you do? And then here, kind of a more practical approach in terms of referring to other resources. I think the answers here pretty much address what you should do pretty well. You just have to kind of combine all the answers into something and put it in your own words for purposes of answering this question. What you really do as an investment advisor in a firm is if you start detecting this and you're working in a firm, is you know that you have some reporting obligations. You might have to file a suspicious activity report in terms of what's called money laundering, even though it doesn't really sound like money laundering. It's basically covered by the money laundering statute out there, which broker-dealers are subject to. You have a FINRA regulation that you have to comply with. Almost every state has got an elder abuse statute as well. Some of the states have adopted for investment advisors the North American State Securities Administration basically model rule that imposes other obligations. So essentially what you would really do is, not being an expert in all of those, is you would go to the compliance officer of your firm and you would involve them very quickly and say, what do we need to do here, and kind of follow the advice and try to handle it. If you're a sole practitioner, a lot of times what you do is you reach out to a compliance consultant, or you reach out to other advisors who may have dealt with this issue a little bit differently. So as someone who's working in the industry, you don't always have to know all these rules and regulations and how to follow them yourself, but you need to know that they're out there, and you need to know that if you detect situations like this, you need to involve other people in your firm to help make sure that what you do is proper. The other big thing here is, of course, if you have a client consent, that you might notify a family member This is something I highly recommend for everybody who works in the financial industry. Basically, consent from your client that you are able to contact one or more named members, and you have their phone number and contact information, so that if you detect undue influence or fraud or lack of capacity, any of these issues, you can diminish capacity. You can involve the other family members in that. And even when somebody is, I had a 90-year-old client, a 95-year-old client. She was really mentally very sound, very sharp. And she always asked me, am I doing okay? I said, yeah, I'm doing okay, but I would like you at this point in your life, even though she was not subject to basically being in a situation where she was going to be subject to a lot of fraud or undue influence. I would like to have a duplicate copy of your statement go to one of her family members and make sure that they were involved and that they could actually have permission to talk with me about their account. So we set that up, and that's quite common when you're dealing with older people. Also realize that older people, um, the they have their skills when it comes to dealing with math and financial decision making goes down dramatically. It actually starts at age 55, which kind of makes me a little worried. I'm 62 now. No, it goes down very gradually, but it continues to go down throughout their lives. But their confidence level in their own abilities remains quite high. So uh, I think part of being a financial advisor is protecting people about making dumb mistakes as they get older. I had a client who called me yesterday. He's in his 90s, and he wanted to buy stock in a fuel cell company he had heard about. So I don't typically tell my clients to buy individual stocks, but in this case, he has a kind of a play account, and I did some research on that for him and told him not to buy it because there has never been a fuel cell manufacturing company that has been profitable for a year or longer. So I was able to point that out, and even though he heard from a relative it was a good deal, you basically try to protect them. At the same time, he wanted to buy Amazon, and I let him do it. So I said, sure, okay, yeah, I'll help you buy that stock. All right. So, any questions? Well, the elder abuse, basically, I'm going to refer you to looking at that Project 13. Planning for higher education expenses. Gosh, just about everybody who has children should be planning for higher education expenses. I think that one of the things that we see, however, is very few parents actually do that. Um, I would see my wealthier parents fund 529 accounts. I'll see grandparents fund 529 accounts, college saving plans accounts for their grandchildren, without really thinking through what the best options are and whether it's going to affect financial aid awards as well. So here we have Brittany is age 1 now. She's going to go to the Western Kentucky University. Again, it was 22,000 a year. We'll say 40,000 a year in 17 years, 160,000 in total. And you have projected if you save 4,000 a year, you will have saved $120,000, which is not going to cover everything, but it's going to be a pretty good sum. But you don't want Brittany to graduate with student debt, so you want Brittany to get some Pell Grants. Well, be eligible for that. Of course, that's dependent upon income and assets and the like. So the question is, how do you save this $4,000 a year? Right. And there are several choices here. And we're going to assume that FAFSA forms are utilized for purposes of qualifying for financial aid. And one choice is to add the amount to a Roth 401k account. You're already making a contribution every year to that account. The other is to fund a Roth IRA account. Another is to pay off the mortgage faster. That way you can actually tap the home equity with either a home equity line of credit or actually get a bigger mortgage at that point to help fund college expenses. Um, you can invest in a 529 college savings plan account, and then either through Kentucky or Utah. And this person is a resident of the state of Kentucky. So if we look at these options and say, well, let's see, Roth 401k account. All right, that's kind of nice. You can actually take loans out against 401k accounts. That's one of the benefits of them. Um, and but typically you can't. I don't believe you can pull money out. And correct me if I'm wrong, but I don't think you can pull money out for educational expenses from Roth 401k. You can for a Roth IRA account. You can also pull out the basis, the amount that you've contributed to a Roth IRA account, you can do as well. Now, there are some income limits in terms of when you can contribute to a Roth IRA. So you have to watch those, and so not everybody can contribute to a Roth IRA. Both the advantages of both a 401k account, traditional or Roth, and a Roth IRA is those assets are counted as retirement assets and are not treated as assets that are available for funding a person's person's college education, the child's college education. Therefore, they don't affect the financial aid award. You can make additional payments of principal on the mortgage. That might be done. It doesn't affect, building home equity does not affect financial aid awards. Or you could put the money into a 529 college savings plan account. And if you were to do that, you would choose Utah's over Kentucky's. Um, Many states have a state income tax deduction if you are a resident of that state and you contribute to a 529 plan account, basically for any relative. In most states, then you get basically a state income tax deduction. So if you put in $10,000 and the state income tax rate is 5%, you basically deduct $10,000 from your income, which at the 5% tax rate saves you $500 of state income tax. Kentucky has a state income tax, but it does not have a state income tax deduction and is unlikely to have one. And Kentucky's plan, so then you look at, well, is Kentucky's plan a good plan to invest in? The fees and expenses of that plan are a little on the high side. The investment choices are not as great. So you would probably choose another state's plan. Utah has a really good one, and there are some other ones out there that have 529 account plans have gotten better over time. Every state has their own one. But Utah, I still kind of favor it uses a combination of dimensional funds and Vanguard funds, and it does a pretty good job there in terms of the investment choices. What would I do here if I would probably, in this case, if I thought that the parents had an income that was likely to not be so high that they would be eligible, their child would be eligible for Pell Grants or other scholarships and the like, I would probably not have the parents contribute to a 529 account. I would instead probably seek that they fund a Roth IRA account. That seems to have a lot of flexibility to it in terms of its use. And also consider making additional payments of principal on the mortgage each year. Maybe splitting that savings in some way. Another concern that I have with basically the 529 accounts, although they grow tax-free if they use for qualified expenses, which now includes not just college expenses, but also private school expenses. But another concern that I would have with them is, what if this move that we have in the country to basically start having the federal government pay for the cost of college, which I don't think will happen, but we could see some type of federal state partnership where the support for higher education becomes a lot greater at some point in the future. Some other countries you can basically go to college, even graduate school, and not pay anything. Anybody who's considering graduate school, even though it's hard to travel nowadays, you might consider going to Germany. You can actually get English taught graduate school and not pay anything there, which is quite a deal. Um, so I would be a little bit concerned just from the standpoint of are we as a country ever going to basically um, pay for college expenses in a different way than they're paid for right now. Now, the second part of this question is kind of makes it a long question here, although the question could be broken into two separate questions if I wanted to on the exam, uh, is that your parents who reside in the state of Illinois have established a 529 plan for the benefit of your daughter. So basically the grandparents establishing an account for the benefit of the granddaughter. By the time your daughter, there will likely be 50,000 in the account. You and your daughter are residents of the state of Kentucky and going to go to WKU. Should your parents contribute instead to Kentucky's 529 college savings plan? No, there's no reason to do that. If they contribute to the state of Illinois plan, they're going to get a state income tax deduction. That's one of the states that have that. Up to $20,000 of deductions a year, and I think their state income tax rate is 4.75% or something like that. So that's a significant saving. Like $950 a year in terms of potential savings. Now, they're not likely to put that much in there, but state income tax savings are nothing to laugh at. That's kind of like getting an instant 5% or 4.75% in this case return on your investment just by making a contribution because you're saving taxes there. Plus, almost I'd say 99% or 95% of the 529 plans out there, you can use that money in that college savings plan for any college in the country and even overseas in a lot of cases. So you're not restricted to, hey, just because it's a state of Illinois 529 plan, this person's got to go to a state of Illinois college. That's not the case hardly ever. So no, they shouldn't contribute to that for basically a state income tax. And when your daughter attends college, what is the potential impact of the account on financial aid awards? Now, at this point, you have to figure out who is the custodian, who is the person in charge of this account. And it turns out that the mother is. All right. What strategies might be utilized if that was the case? And I am just going to pull up my answers to my projects, and I'm just going to type in 529, and here we go. This questions on cost on 529 plan accounts, and this whole project here, and here we go. If grandparents on the account, the financial aid award would not be reduced. However, the distributions can count as untaxed income to the beneficiary. How do you work around that? Well, there's several. One is you could actually change the custodian or the account owner. All right. The other is to roll over the 529 plan accounts to another plan. If the rollover occurs after the FAFSA is filed, the funds won't report it as an asset. Distributions will not affect the eligibility because then the 529 plan is owned by the parent. Another is take a distribution later. If the student is only going to go to college for 4 years, wait until January 1st of the beneficiary's sophomore year to take a distribution, because FAFSA form uses the prior year income and tax information. So basically, even in the senior year, September of the senior year, they'll be using information from the prior year for determining college age awards. And the other is wait until after graduation. You can use up to $10,000 to pay all down student loan debt. So kind of the outline of how to answer that question is all here in this project. What project number is this? It's project 14. All right. I think
Dr.
it's,
Rhoades.
yes.
I have another question about 529 plans that we didn't address, but I was just curious about.
Sure.
What should you do if you have twins? Can a 529 plan fund two beneficiaries or just one?
You got to have one for each one. You can't have multiple beneficiaries on a 529 account. Realize, however, that you can change the beneficiary of a 529 account at any time. So let's say one of the twins goes to a state university and gets a full ride scholarship, and the other one goes to Harvard. You can actually change the beneficiary on the account and basically use all of those funds for the other student. Yeah. And if you have unused 529 accounts, you can change the beneficiary, for example, from your child to a grandchild when you have grandchildren. So that's just another part of that. Good question. Yeah. You can't have 529 accounts for a group of people. They have to be for specific people, a specific person, okay, whose name is the beneficiary. Whenever I deal with 529 college savings plans, I go to that website. By the way, it's called Saving for College, I believe it's called. It's like the place to go for 529 plan information. So if I have like a resident of the state of New York who's contributing to somebody, I will go there first, and then I'll actually go to the state plan's website, pull up the documents of that plan, and try to verify all the rules that might apply, make sure that I've got my ducks in a row before I give advice. Just generally speaking, when you give tax advice to a client, I always like to verify it before I give it, because tax rules change too often. So even in a case like this, I'd say, gee, I know pretty much what the rules are on grandparents, but I'm going to go back and revisit them and make sure I fully understand them there. Okay, on to the next question. Any questions before we go on? Okay. Protecting assets upon marriage. All right. You're age 40, your uncle's very rich, doesn't have any children, and you are likely to be his sole heir. Isn't that nice? But your uncle has fallen in love. Your uncle's retired, has a net worth of $2 million, and his bride-to-be is age 68, retired. But fortunately, she has her own net worth. So this is not an abusive situation. This is two rich people who maybe met on a cruise or something and said, hey, we want to get married. All right. And they're not taking a huge amount out of their portfolios. They're going to be residents of Kentucky. Should they get a prenuptial agreement? Yeah, why not? What does a prenuptial agreement cover? It says, this is what happens if we ever get divorced, and this is what happens if either one of us dies. And in both those cases, they might say, we're just going to keep our own assets. We're both independently financially secure, so we don't need anything from each other in the event of divorce or death. Okay? What happens if they don't get a prenuptial agreement and later die? Does the new wife have any potential claim against the assets? And the answer is yes. You need to explain how dower works under Kentucky law. I believe it's 30% of the real estate and 50% of the personal property is subject to dower, and that could be a significant impact on in this case, your inheritance. So you need to get a prenuptial agreement in which those rights are waived. The dower rights are waived. Or in a lot of states, Kentucky is kind of backwards. It's one of the few states that have dower and courtesy, which really goes back to Old England law. Most states have something called the elective share, and you don't get into whether dower applies to homestead property or whether it applies to accounts with a beneficiary on a life insurance that may or may not have a beneficiary. You don't get into all these interesting questions about that. You basically have an elective share statute that says whatever the person owned, regardless of who the beneficiaries are named, a person can elect to take 30% of the value of that from the person's estate or trust, or from or levy upon the actual accounts themselves if that's the way you have to do it. So basically you have a claim against the estate, and then the estate might have a claim against the accounts. And elective share the amounts can vary, 30%, 40%, 25%, and like. But so if they were to move to another state, their prenuptial agreement would say, we waive all rights to dower and curtsy and elective shares, and basically there's some legal language there, right? So you don't want basically them, you definitely want them to get a prenuptial agreement just to waive those rights. Do they have to leave each other anything? All right. Well, no, they don't have to in this case, because each of them is independently wealthy and financially secure. So there's no reason for them to be mandated, even if they were to be married for 30 years. Right? There's no requirement for doing that. However, if one of them was worth a lot less, a prenuptial agreement must be fair to the spouse upon a subsequent divorce or death. So you don't want to leave spouses destitute. So what's fair? Well, if they were married a year or up to a year, it might be a certain amount that is distributed, or a percentage of the assets. The longer they get married, like every 3 or 5 years, a higher percentage results, or something like that. Or the agreement actually specifies that an amount is going to be put in trust, and that trust will deliver a certain income level to the survivor, such as a Q-tip trust. So there's a lot of different ways of addressing how to support the surviving spouse fairly, or a spouse if there's a subsequent divorce and people have been married for a while. What about the home? Now they're going to they plan to live in your uncle's home. One of the things you want to address here is, hey, if the uncle dies and the home is in his name, you want to make sure that the bride here has got some time to move out. They might be given an option to buy the house if they want to, so they don't have to move. Or they might be saying, the house will be maintained for you for a period of like 6 months or 9 months, and allow you to live in the house and then set up a place to that way they can set up their own home or move someplace. A lot of times when something like that happens, you have to kind of realize, well, where is the spouse's kids at? Because they're more likely to move closer to their own children at that point. It's also quite expensive to maintain a house. So I've had clients in my legal practice basically said, if I pass away, I want this house to be maintained for the benefit of my surviving spouse for as long as she wants to live there. And that could be 20, 30 years. Well, the cost of maintaining a house, even when it's fully paid for, real estate taxes, maintenance, insurance cost, then you have to think, well, who's going to mow the lawn? Who's going to, who's going to do the weeding? Who's going to, basically all these other costs could easily add up to a very significant sum every year. $10,000, $15,000, even $20,000 a year when you think about it. Plus you've got somebody who's got to, so you got to set aside a fairly large sum to maintain a house over time. Unless you start charging them rent, which then creates interesting tax situation. So a lot of different ways of structuring that, but basically in a case like this, you would likely say the surviving wife here would be able to buy the house at its fair market value as determined by an appraisal done by the executor of the estate, or would be able, or that the house would be maintained for a period of 6 or 9 months and let them move out. Can you recommend an attorney that represents both of them to prepare a prenuptial agreement? In a case like this, you would be tempted to do that because they're basically just waiving each other's rights, except for this home situation. It's a little bit complicated, and that seems to be worked out fairly. However, if you want to, if somebody were to challenge that prenuptial agreement, and let's say the uncle has an attorney and the wife is moving into the neighborhood and does not have a prior relationship with the same attorney, which is very much the case, or even if they did have a prior relationship, if you want a prenuptial agreement to be enforceable, you make sure they get independent legal counsel. It is so easy to assert, this attorney represented both parties, this attorney had a conflict of interest, even though they might have waived that conflict of interest. Because of a prior relationship, there was undue influence being exerted. And of course, you may not have the records to go back and show that there was an undue influence exerted, but there is almost a presumption of undue influence. So always, always have people who have their own attorneys. It's basically insist on it. I've had a case where uh, the woman, my client, the man said, I don't want to even have an attorney. I'll just review it myself. And said, you're not going to get married unless you get an attorney. We are not going to allow that to happen because it was a fairly complicated agreement and I wanted to make sure he got legal advice. And that helped. That helped when she subsequently died. And he was considering challenging the agreement, but because he had gotten legal advice, he really would have an uphill battle trying to do that. So any questions about that? Protecting assets upon marriage? This is a fairly easy question. Didn't get into all of the intricacies of dower and courtesy and what it applies because the rules here in Kentucky tend to be a little on the complicated side. But just get into the practical solution of, yes, you got a second marriage situation, older people getting married, makes it fairly easy. You don't have to design out, financial support and all that. As a financial advisor, you might get involved in the process at some time, but most of the time the attorneys are going to handle that pretty well on their own. Any questions? Oh. Travis says, can you list yourself as a beneficiary on a 529 account and put your child's name on it later? That's a good question, Travis. I don't see there's any reason that you can't do that. That might be interesting to do. I'd have to look up the rule. Can you name yourself as beneficiary of a 529 account? You might find that under a state, it says you can only name people who are related to you, but it doesn't list yourself. And the reason for that is that maybe the state does not want you to get a state income tax deduction for basically giving money to yourself, for example. So I would think that maybe the answer is dependent upon the state statute in that case. I've never heard of somebody setting up a 529 account for themselves. But I understand where you're coming from. You get basically better compounding that way the earlier you put into it. But I would check on that with a specific state that you might want to set it up with. Could you name your wife? I think you can name a spouse in most states, yes. And Travis says, you don't currently have kids, but you plan on it. All right, we'll let you have 20 kids and let you go from there. All right, got a few more questions here. Taking on a partner, buy-sell agreements. You're a financial advisor. You have $200,000 in gross revenues. You meet another one advisor who's got a very similar to yours. You decided to become partners because that way you can lower certain expenses, share some software, for example, and you provide for a succession plan. You expect that by combining forces, you can also attract more clients. Makes sense. Clients might not be willing to work with a sole practitioner because they kind of wonder, well, what's going to happen if you pass away? Your goal is that each of you are going to build up the practice and make more money. So you want an attorney to prepare a buy-sell agreement. Your attorney has only drafted a handful of these agreements before, and even if they drafted a lot of them, a lot of attorneys have never done this for a financial advisory firm. So the questions is, the attorney asks you, what method will you utilize to value your firm and each person's 50% interest in the firm should either of you die, all right? And that would trigger the survivor review to have a mandatory buyout of that person's interest, all right? Well, basically the question is, how do you establish the value? All right. And there's a lot of different ways of establishing values in buy-sell agreements. There's a lot of formulas out there. You can agree on what the value is. I would say that if you agree on what the value is going to change over time. And almost every time I've seen people say, we're just going to agree on it every year. Typically, they don't go back and agree on the value every year because it's just not on their radar. And then one of them will die, and you find out that you don't have any value set, or the value was set 7 years before, or something like that. In financial services firm, there are different ways of valuing firms. There are about 5 different types of ways that you typically value a business under the IRS guidelines. You can use any one or more of those combinations. But in financial services firms, a lot of times the value based on multiples of the gross revenue. If you're a commission-based practice, that could be 1 times the commission-based revenue. If it's a asset under management approach where you have ongoing revenue, a lot of times that's 2 times revenue for a smaller firm. And larger firms, it could even be more than that, depending on how the firm is structured, if it's a true team environment, things of that nature. Somebody might be hesitant to say, I'm not sure I want to buy, your interest out for 2 times. What if I don't keep these clients? And I think one of the best ways of addressing that is just that you're going to pay a percentage of the revenue that's collected from those clients, actually collected over a period of 5 years. So for example, if the valuation is 2 times the value, you pay 40% of the revenue that you actually collect over 5 years. And if the client leaves and doesn't go with the partner, that's a risk that the deceased partner and estate or trust would have. If the client starts bringing in more money, that's a benefit as well. It actually encourages, basically, when you have an agreement like that where you tie it to the actual revenue received, it encourages each partner to basically make sure that the other partner knows their clients and the clients know them, so that the clients will stick with the firm. So I kind of like that arrangement. I think it removes a lot of the risk that either one of them has. Assume that you purchase term insurance to fund or at least partially turn the purchase price. Let's say you go out and buy $500,000 of term life insurance. Who's going to own it? You own the insurance on your partner's life. If you have more than one partners, I had 2 partners at one point. We had term and life insurance on each other. So one of my partners, John, myself, and my other partner, Mike, owned the policy on his life. We were equal owners of the life insurance policy on his life, and vice versa among the 3 of us. Right? We were also named the beneficiary, because then we would get the cash. And under our buy-sell agreement, we are mandated to use that cash up to the level of the value that was established. So we did have a formula that applied in that case. It didn't. So if the value was lower, we would keep the extra cash. If the value was higher, we would use all of the cash received from that life insurance, and then the rest would be set up usually with a promissory note where we would pay out the balance over time. That's one way of doing it. So just be aware that the typical buy-sell agreement is called a cross-purchase agreement. You will see in some companies, especially C corporations, where there are many, many different shareholders, you'll see something called a redemption agreement where the firm actually buys the stock. We have a lot of different shareholders. A lot of times it just makes sense for the firm to buy it. there's some other devices where you have multiple partners where you can set up what's called a voting trust arrangement, where basically a trust buys it on behalf of all the other partners. There's an advantage to having the partners buy the stock or ownership interest of the deceased member, and it all relates to establishing the basis in the stock. From the standpoint, if you have the corporation buy it, you're basically not establishing a basis in the stock at that point. So from a tax standpoint, buy-sell agreements are typically utilized unless the firm has gotten really big. Any questions on that? All right. You're successful. You desire to leave Merrill Lynch. You were hired. You've built a book of business. You're making $500,000 a year revenue, but you only receive the typical payout, which is in the 35 to 45% range, about $200,000, and you don't really own anything at that point. But Merrill Lynch provides you with an assistant, marketing support, office space, their advertising, their relationship with Bank of America. Merrill Lynch is owned by Bank of America, provides you with a steady stream of new clients. So even though you don't own the relationships, basically as an employee or an independent contractor, you have a lot of support from them. But you said, I want to start building equity and I want to go out on my own. The problem is you've signed a non-solicitation agreement. What do? What steps can you take if you leave your firm? And what steps can you not take? Well, probably the number one thing you do before you leave your firm is contact a securities law attorney. And there are some nationally that specialize in this. And they would also identify a local counsel to handle any court cases. But basically those national attorneys will, there's several of them out there, will help you through the process of what you can and cannot do if you leave one firm to join another firm or to start your own firm. You cannot violate the solicitation agreement typically by, for example, going out to a client's house either before or right after you leave, or even a month or a year up, whatever the term of the non-solicitation agreement is, saying, dear client, I'd like you to come with me. You can't do that. That's the type of direct solicitation that is prohibited. But you can, run an advertisement in the paper that you've opened up your own firm and you're accepting clients. That's a general solicitation. We have basically freedom of business enterprise and a freedom of commercial speech that has been ruled in almost all states to override the restrictions of a anti-solicitation clause. On top of that, you could meet somebody if you run into them at some point. And in some states, non-solicitation covenants have been weakened in terms of what you can and cannot do. So basically it becomes a state-specific thing. Now we had a question that was in the, as all of these questions are derived from the project-based questions, and there was a list of several things that you could do there and not do, and I answered those questions myself in the document. So I would point you to that to try to help figure out some of the more specific answers to that. All right, we got two more questions here. One is, got $100 million, aunt and uncle who'd pass away, right? They had no children, and you're in the sole heir. Other than their $10 million home, $90 million of that is in a diversified portfolio. It is liquid. You can transform it into cash fairly easily. What is the federal estate tax exclusion amount per individual, and how much federal estate tax will be owed? Basically, it's the $100 million minus 11.58 million each. So you come up with around, what is it, 76 million and change, times 40%. The federal estate tax rate is a flat 40% over and above the exemption. So 40% times 78 million is, I don't know, 30 million or something like that. Just to kind of do the math there. Right? If you were in charge of that and you were able to sell all of the stocks, all right, and that sale of stocks occurred 1 week after both of them died, and there was no change in the value of the stocks, how much capital gains tax would you have to pay? The answer is none, because of the stepped up basis. All right. All right. Assume that all the capital gains were long-term capital gains, and Florida imposes no state income tax and no state tax on tax, and assume that only the federal income tax rules apply. Basically, none of that matters. For both state and federal income tax purposes, there's elimination of all capital gains and losses when someone dies. It's the stepped up basis that occurs. Now, stepped up basis does not occur for certain types of assets, and one of those is traditional IRA accounts, traditional 401k accounts. Roth accounts don't get a stepped up basis, but they don't need it because it's all tax free. Non-qualified annuities, where somebody actually goes out and buys like a variable annuity, puts 100,000 and it grows to 500,000 and they die. There's no stepped up basis in that, which is one of the downsides of variable annuities. But that's not part of this question. I was just kind of elaborating a little bit. In this case, all capital gains and losses are eliminated. So that's a fairly short question, two-part question. Here you have a little bit more complicated question. You have 5 nieces and nephews, and they also are charitably inclined. Then one has got student debt. They don't want the nieces and nephews to become dependent upon them. At the same time, they do want to fund educational expenses and handle things if there's adverse financial circumstances. And they don't want to gift outright any sums of money to them. And they want to ensure that if they pass away, no substantial money other than for necessary healthcare, education support, and maintenance flows to the nieces and nephews prior to the age of 35. So you have somebody who's got outstanding debt. You've got another one here who has graduated from WKU, has no student loan debt, but unpaid medical expenses. We got somebody else who's got tuition expenses and some other expenses. Another one is starting college in 4 years, going to Yale, pretty expensive, anticipates living expenses on top of tuition and books. Another one is going to attend college 13 years from now, all right? Parents are going to have substantial income, so no financial aid awards. And we have James and Jenny Moore, residents of the state of Texas, which we are going to assume has no state income tax, which is true, no gift tax, and no state inheritance tax, or no state estate taxes. So only dealing with federal estate and gift tax issues there. They have a net worth of 100 million, they have a home, they have a traditional IRA, and then they have individual stocks, and all of those are in stocks and bonds. Those are all liquid. They possess substantial income. They're in a top tax rate. They would feel comfortable giving up to 25% of their net worth now, so 25 million, if it would save substantially in taxes. And you believe it is unlikely that the current federal state gift tax exemption will continue after 2025. It actually becomes half of that because of the way the legislation was done several years ago. They could only keep it in place for so many years because they didn't have 60 votes in the Senate to make it a permanent tax law change. And I would guess that after our economic crisis here, that there's going to be a lot of pressure on to raise taxes to help balance the federal debt and deficits and address our deficits. So my guess is that these federal, state, and gift tax exemption will be lowered. They do think that the federal state tax rate would probably remain the same. I'm not 100% sure of that. But the IRS did recently state that if you use up this 11.5 million exemption that they have right now, and the exemption goes lower in the future, so if you were to use that by making a big gift during your lifetime, and then the exemption goes lower, you're not going to be subject to gift tax. So for somebody in this situation, using up their big exemption now is a good idea. It also shifts the appreciation of those assets out of your estate. So when you think about it, hey, that's something that you could do. They want to, basically you need to discuss the gift tax exclusion for tuition, for medical expenses. How does that apply to this situation? You could set up an irrevocable trust called a crummy trust. You can use the annual gift tax exclusion for that. If it's not used for other purposes like direct gifts, you might want to consider whether to purchase life insurance in the crummy trust. Now, some people would be willing to go out and devote money to buying like a joint and last to die, a whole life policy, or a variable universal life policy, and that. It does grow income tax free, and then the trust basically is the owner and the beneficiary of it. Others would say, I don't want to spend that money on life insurance. I'll just have it invested in the trust and the like. You don't really have a liquidity need here that you need to solve. Probably the biggest problem here in terms of buying life insurance is the high cost of life insurance relative to what you might get if you were just to invest that money in a fairly tax efficient manner. So you might want to do that. Another question is whether there should be a family trust and a Q-tip trust. And the answer is, yeah, probably. One of them might be concerned here that, hey, if I do have an exemption left when I die, if James were to pass away, whatever his exemption is used to establish what's called a credit shelter trust, also called a family trust, in which Jenny Moore and perhaps the nieces and nephews are all beneficiaries. So distributions could be made out of that trust for those purposes. The rest of the money could go into a Q-tip trust for Jenny Moore. Maybe she gets she's required to get all the income from a Q-tip trust. The benefit of that is really if James says, I want to protect this money, make sure it goes down to my nieces and nephews and not to anybody that my spouse might subsequently marry. So basically, a Q-tip trust might be a device to keep things in the family. And so chances are you want to discuss what a family trust is, a Q-tip trust. Qualified charitable distributions. If they are 70 and a half or older, they can take money out of a traditional IRA up to $100,000 a year and contribute that to charity. Now, there's no required minimum distribution until age 72 now, but the age for taking a qualified charitable distribution remains at 70 and a half. There's no required minimum distribution at all this year under the CARES Act for people. I don't expect you to know that, but you can realize that the qualified charitable distribution can be used as part of Jenny's required minimum distribution, so it would lower the amount of taxable income to her. That's a great way of contributing money to charity. Should they gift other monies to the WKU Foundation during their lifetimes, or wait until they both pass away? So let's say they want to give a couple $1 million to the WKU Foundation. It makes sense for them to do it during their lifetimes because they're going to get an income tax deduction for that. They're up to certain limits of their income. So by giving during their lifetime, they're going to save income tax. So basically the IRS is participating with them in these charitable gifts. If they do it upon the death, yeah, it lowers the value of their estate for estate tax purposes as well, but they don't get the income tax deduction. So it's usually a lot better if you're considering leaving things to charity. An alternative here would be that traditional IRA could be left to charity. Because if you leave it to individual persons, not only is there estate tax on it, but there's also income tax on it. There's kind of an offsetting deduction partially there. You don't need to get into the details of that. You don't even need to mention that. But basically leaving a tax burden to heirs is not something like heirs want. But if you leave that IRA to charity or to a charitable trust, that would work. And another thing they could do is convert that traditional IRA to a Roth IRA, let it grow tax-free. It reduces the value of their estate by the income taxes paid, but now you have tax-free growth as opposed to tax-deferred growth. So there might be some benefits there. This is a pretty long and complicated question here. It really wants you to kind of navigate all of that. I am not going to go over all the answers to this, other than to say that tomorrow morning, when 6 o'clock, will be made available to you my answers on Project 18. And all of those answers are relevant in terms of answering this question here. So I would encourage you to look closely at that document. And then if you're working on this in anticipation that this question might appear on the exam and you have questions, obviously feel free to email me with any questions that you might have, and I'll try to guide you through it. Okay, how was that? We've gone for an hour and a half. I think we are at our limit here. Any specific questions before I sign off? Okay, great. Again, reach out to me if you have any questions. Between now and the time of the exam. We got another question. Yep.
Sorry. This is about the CFP and the future of well, think
You're breaking up. Can't hear you.
fail grade. Oh, do you think that there are negative consequences for taking a pass D fail grade for a class if you're pursuing a CFP designation degree career?
No, we've actually checked with the CFP board, and there's no downside to that at all. And I don't think there's any impact on your career at all. So don't worry about that. Okay.
Thank you.
Good question. Okay. Thank you all for coming, and I'll be posting this video shortly on YouTube and sending out an announcement.
All right.
Thank you again.